This one comes out of Washington. It involves the same group called Peridot or Peridot Tree. I'm going to say Peridot because maybe it's a French word. And a California attorney by the name of Jensen, who's been bringing suits all over the United States, including California, New York. And he's trying to challenge these local restrictions in the equity cases that you have to have lived here or you have to be involved somehow in the state to have qualified for these equity licenses. Now, we talked about this case some time ago when the court denied an injunction. They weren't going to stop the Washington licensing process for these equity applicants because these folks filed a case. But now the same court came back and sort of tore this guy a new one. And the battle here is between the legal aspects of cannabis or marijuana across the country and what we call the de facto. What the hell is going on the ground? Because we all know that since the Rohrabacher-Farr Amendment, cannabis policy has been muddled at best, where the federal government has been defunded. The Cole memo, directed them don't go after certain groups if they're following state law. Rohrabacher-Farr and its iterations have said, no, you can't spend any DOJ money to go after people. But irrespective of that, marijuana is still a Schedule I drug, and you can't touch it, possess it, grow it, move it across interstate, state lines, anything. And this all goes back to the Rage case from 2005 out of California here, where they resurrected this old New Deal case, Wickard versus Filburn. I think we've talked about Clarence Thomas's feelings about this. And at some point, I think we're setting up for a battle here because the federal government's jurisdiction is based upon there being not only a prohibition against marijuana, but a uniform policy across the country. And that's where this thing falls apart, because there is de facto an interstate commerce in marijuana, whether it's for medical or recreational. You're finding California weed in New York, New Jersey, all over the damn place. And in the main case, that's where an appellate panel hung their hat. They said, no, there is a de facto, they didn't use the words de facto, but they noticed that there is an actual interstate commerce in marijuana right now, even though it's illegal. We're going to recognize that as commerce, and they busted through the legality argument. And the dissenting judge in that 3-panel is where the legalists now are hanging their hat, because it's what the story is, and I think the case law bakes this up, is that it's illegal under federal law, and the Congress acted under its commerce power to declare marijuana to be illegal. Can't do it. Okay. And they've been trying to tear that apart, and we're still talking about the Schedule III nonsense. And this whole story's beginning to fall apart. Legally, marijuana is still as illegal today as it's ever been. It's just a challenge for the federal government to go after it. That doesn't change the legalities. So what the Washington court said is that, pack up your dolls and get out of here. Is that this is illegal under federal law. States can do whatever the hell they want, because the federal government has acted and stated there's no interstate commerce here. Therefore, the Dormant Commerce Clause doesn't apply. Now, we're going to see this continue to roll out, and I'm not 100% sure how it's going to get before the Supreme Court, because they're arguing they don't want to have a circuit split here, which means that different appellate circuits have different opinions. There's been a ruling already on this Peridot group in California, but they specifically didn't rule on the merits of the Dormant Commerce Clause. So my prediction is if this gets before the Supreme Court before the rescheduling debacle starts to take effect, we may have the courts pull the plug on a lot of this and declare that Raich was just not well founded. The 10th Amendment is a real thing, and allow perhaps a more wide open interstate commerce on this. We'll wait and see and reserve some judgment. I'm going to throw it back to you all for your comment. What do you think about this?
You're on mute, Jay. I'm going to say this. They totally did miss it on the Raich decision. The Supreme Court, I think it was 5-4, if I recall right, Dale, on the Raich decision?
No, I think it was more than that, but there was some significant dissent. It's Thomas's
Right. Maybe I'm
dissent.
thinking of
Now it's come
OCBC.
back to haunt
One of them was 5-4. But my point is that the court super missed the ball on the Raich decision. The basis of the Raich decision is that, in theory, a black market in California could, in theory, affect a black market in another state. Hence, the interstate commerce is now invoked and the feds have jurisdiction. That is so contradictory to the 10th Amendment. And not only so contradictory to the 10th Amendment, but to the sentiment of our founders when they established this system. In no way, shape, or form, if a plant was grown, sold, and consumed within the border of a sovereign state, would any of our founders said that the federal government had jurisdiction over said plant or commodity or insert anything here.
Well, how they came to that decision, if you look in the comments in the Raich decision, as far as what the judges related cases in regards with their thought process, if I remember correctly, that was all about yeast. It was about a previous ruling that they had in regards with yeast and commerce of yeast. Yeah, wheat. There we go. Thank you. Yes, Dale. So, but if this judge rules contradictory to the other district court judge, doesn't that just force the Supreme Court to take this measure up to issue a final ruling for the land, since you have two different district courts having two different types of opinions?
Well, it certainly can, but going to the Supreme Court is discretionary. They don't have to take these kinds of cases. They can wait until they see this is a boiling point. And I don't know if it's a boiling point yet, because there's a lot of interstate commerce problems out there, and this could get lumped into them. And where that line between the federal commerce power and the state's 10th Amendment traditional police powers is where these lines are really muddled right now, because in fact there is a semi-legal interstate commerce right now in weed. Okay? And it's not fully legal, but it's there. It's de facto. And the federal government has weakened its position so much that the Raich case stands on you've got to have a firm, solid federal prohibition in place, and then the commerce power applies. That doesn't exist anymore.
Isn't that why they
all muddled in a gray area?
Isn't that why they call it the law of the land now, Dale?
Well, it's the law of the land, but what Clarence... Go ahead, Dale.
Oh, we've always had the law of the land, and our laws tend to try to catch up with what people are actually doing. That's why we distinguish between de facto and de jure. De jure marijuana is fully illegal. De facto, you can get it any goddamn place you want to. Okay, and that's the tension right now, is the people want this, and the courts are trying to draw hard legal lines when, the reality is you can't control this anymore, so let's see if we can move away from a hard legal line. And that creates all sorts of problems, because everything today crosses a state line, and the feds could claim jurisdiction over everything in your life.
Yes. So the interesting part about this, though, Jason, is that the conservatives on the court right now have already signaled that the situation that Raich was decided in is no longer there. That has been signaled from the court. So it's an interesting position to take, to say, okay, if this comes back before us, the basis that this court made, that the basis that this court used to make its ruling no longer exists. The legal landscape that they used has completely changed. So I'm actually really optimistic. If this goes before the Supreme Court, I think it gets overturned.